It was a war without bullets or bombs, but it shook the tech world. In 2011, Apple opened a new front in its fight to dominate smartphones, a legal onslaught against Samsung. Steve Jobs himself had been fuming, calling Google's Android a stolen product and vowing to go thermonuclear to destroy it. This thermonuclear war would play out not on battlefields, but in courtrooms around the globe. Why would a CEO use such extreme language over a phone? The answer lies in the iPhone, Apple's crown jewel, and a fear that it was being copied. What followed was a saga of patent lawsuits and dramatic trials lasting 7 long years. Let's dive into the story of Apple versus Samsung, a high-stakes feud that would change the smartphone industry. In the spring of 2011, tension in Silicon Valley was palpable. Apple had revolutionized the mobile phone with the iPhone a few years earlier, and now Samsung, one of Apple's own suppliers, released a smartphone that felt eerily familiar. Samsung's Galaxy S was sleek, glossy black, with a grid of colorful app icons and a single round button. To Apple, it looked like a mirror image of the iPhone. Apple's reaction was swift and furious. On April 15, 2011, Apple filed a lawsuit accusing Samsung of slavishly copying the iPhone's design and user interface. Apple's spokeswoman didn't mince words. "This kind of blatant copying is wrong," she declared. The message was clear. Apple believed Samsung had crossed a red line. After all, Apple had spent years and billions in R&D to create the iPhone's iconic look and feel. Seeing a rival handset that could be mistaken for an iPhone was, to Steve Jobs, an unforgivable sin. Samsung's Galaxy S and Apple's iPhone 3GS shared striking similarities in design and icons, evidence Apple used to claim Samsung copied the iPhone. What made Apple even angrier was that Samsung wasn't just any competitor, it was also a partner. The Korean company supplied Apple with chips and screens, making them strange bedfellows, business partners by day, fierce rivals by night. Inside Apple, Steve Jobs' frustration had been brewing for a while. Back in 2010, Google's Android software began appearing on phones with features that seemed to mimic the iPhone. Jobs felt betrayed, especially since Google's Eric Schmidt had sat on Apple's board. When HTC, another phone maker, unveiled an Android phone with pinch to zoom and other iPhone-like features, Jobs lost his cool. He told his biographer he'd spend every penny of Apple's $40 billion to right this wrong, calling Android grand theft. This was personal. By 2011, Samsung's Galaxy S was the boldest Android challenger yet. It ran Android, looked like an iPhone, and was selling fast. Samsung's rise in smartphones was quite threatening to Apple, one analyst noted. In just a few years, Samsung had gone from a minor player to a serious contender, shipping millions of smartphones and aiming for more. Apple, which had virtually created the modern smartphone market in 2007, suddenly saw a key rival encroaching on its turf. Was Samsung genuinely copying Apple's homework, or was this just how competition works? That question would soon be decided in court. Apple's lawsuit in California was only the opening salvo. Samsung hit back within days with countersuits of its own. The South Korean firm sued Apple in Seoul, Tokyo, and Germany, claiming Apple actually infringed Samsung's patents for wireless technology. It was a classic tech industry knife fight. Apple accused Samsung of stealing designs, and Samsung accused Apple of stealing technology. The patent war had officially begun. Both companies knew the stakes were enormous. The global smartphone market was worth hundreds of billions of dollars, and whoever led in innovation or controlled key patents could tilt the market in their favor. By late 2011, Apple and Samsung were entangled in about 20 cases across 10 countries, from the US to Europe to Asia. It was a rapidly expanding conflict. Little did anyone know it would grow to over 50 lawsuits worldwide over the next year. This wasn't just a spat over one phone. It was war for smartphone supremacy. In the summer of 2012, the patent war's main theater was a federal courthouse in San Jose, California. Inside Judge Lucy Koh's courtroom, Apple and Samsung assembled formidable legal armies. Dozens of lawyers, expert witnesses, and company executives packed the courtroom, surrounded by stacks of documents and blown-up technical diagrams. The atmosphere was tense. It felt like a war room for two tech giants preparing for battle. Apple's case centered on a simple question: did Samsung copy the iPhone? To convince the jury, Apple's lawyers brought in physical evidence that captivated onlookers. They showed side-by-side comparisons of Apple and Samsung devices, phones, and even packaging, to highlight uncanny similarities. They unveiled internal Samsung documents where Samsung's own engineers had analyzed the iPhone feature by feature, down to the placement of icons and the feel of scrolling. It was as if Samsung had a checklist to make their phone more like Apple's. One of the most dramatic moments came when Apple revealed something secret: early iPhone prototypes. Apple's designer Christopher Stringer took the stand and pulled back the curtain on Apple's design lab. The courtroom projector displayed photos of iPhone mock-ups and rejected designs, some square, some with curved backs, even one that looked more like a Sony device than an Apple gadget. These were designs Apple had never shown the public before. Why expose them now? Apple wanted to prove that its final iPhone design was unique and hard-won, not something Samsung could simply clone. Seeing these prototypes was like peeking into Apple's vault of secrets. It underscored how seriously Apple took its design, and how insulted it felt by Samsung's devices. Apple even unveiled confidential iPhone prototypes, like the one shown here, during the trial, to demonstrate the intensive design process behind the iPhone. At the heart of the trial were key patents and features that defined the smartphone experience. Apple accused Samsung of infringing several of its most iconic innovations, things users took for granted every day on their phones. One was slide to unlock, the satisfying swipe gesture to unlock the screen. Another was the bounce back, rubber banding effect, that springy bounce at the end of a scroll list, which Apple had patented. Apple also pointed to tap to zoom and pinch to zoom multi-touch gestures, and even design details like the rounded rectangular shape of the phone and the layout of icons in a grid. To Apple, these were signature elements of the iPhone's magic. Their argument: Samsung didn't just take inspiration, they lifted these elements outright for Galaxy devices. Samsung's defense, of course, was that it did nothing wrong. Samsung's lawyers argued that many of these features were either generic or developed independently. They combed through tech history for prior examples. For instance, they pointed out that a device in 2005 had a similar unlock gesture, and that rounded rectangles were everywhere in electronics. Smartphones, they contended, naturally converged on certain designs. Large touchscreens will tend to be rectangular after all. Samsung also fought back by claiming Apple violated some of Samsung's own patents on wireless transmission tech. It was a lot for the jury to take in, a crash course in patent law and design aesthetics, all condensed into a few weeks of testimony. The trial had its share of fireworks beyond the dry technical details. Judge Lucy Koh became a bit of a celebrity for her no-nonsense management of the proceedings. At one point, Apple's legal team submitted a 75-page list of witnesses for rebuttal, an overwhelming move as the clock ticked down. Judge Koh was not amused. "Unless you're smoking crack, you know these witnesses aren't going to be called," she scolded Apple's lawyers in exasperation. Apple's attorney nervously replied, "Your Honor, I'm not smoking crack," to laughter in the courtroom. It was a rare glimpse of humor in an otherwise high-stakes showdown. The judge's crack remark made headlines and underscored how intense the trial had become. Even the judge was at wit's end. After weeks of testimony and evidence, the case went to the jury, 9 ordinary citizens tasked with deciding the fate of a billion-dollar question. They had to answer: did Samsung infringe Apple's patents? And if so, how much should Samsung pay in damages? In August 2012, the verdict came: a resounding win for Apple. The jury found that Samsung willfully infringed several Apple patents and trade dress rights. The infringing features included the bounce-back effect, tap to zoom, and on-screen navigation on Samsung's devices. They also agreed Samsung had copied design elements like the iPhone's rounded corners, home button, and icon grid. Apple's claim that Samsung copied the iPad's design was one of the few things the jury didn't uphold, but that was small consolation for Samsung. The damages the jury awarded were eye-popping, $1.049 billion to Apple. It was one of the largest patent awards ever at the time, and a sharp rebuke to Samsung's strategy. To the world, it looked like Apple had crushed its rival in court. The headlines declared Apple's massive victory, and some wondered if certain Samsung products would be banned from sale as a result. For Apple, this was validation. For Samsung, a stinging defeat. The courtroom war room had delivered Apple a big battle victory. But the war was far from over. Samsung immediately vowed to appeal, and a global chess match was only just beginning. Even as the California trial grabbed the spotlight, parallel battles were raging across the globe. Apple and Samsung weren't content to slug it out in one country. They opened fronts on multiple continents, each with different laws, judges, and outcomes. By 2012, the two companies were embroiled in more than 50 lawsuits in over 10 countries. It was truly a global patent war, unprecedented in scale. If one courtroom was the main battle, these were the skirmishes that together formed a world war of litigation. The results around the world were a mixed bag, a legal tug-of-war where each side claimed wins in different places. In Samsung's home turf of South Korea, a court delivered a split decision in August 2012. It found that Apple had indeed infringed some of Samsung's technology patents, while Samsung had violated one of Apple's patents. Rather than declare a clear winner, the Korean court ordered minor damages to both sides and even imposed a temporary sales ban on a few older models from each company. Notably, that court rejected Apple's claim that Samsung had copied the iPhone's look and feel, saying there was no possibility consumers would confuse the two brands' phones. In other words, in Samsung's backyard, Apple's copying accusation didn't stick. Across the Sea of Japan, Apple sued Samsung in the Tokyo District Court. The result? Another win for Samsung. In late 2012, the Japanese court ruled that Samsung's Galaxy phones did not infringe an Apple patent on syncing media playlists. The judge even ordered Apple to pay Samsung's legal fees. Apple's claims were once again turned down, with the judge dryly noting that Samsung hadn't borrowed Apple's technology in that instance. Europe became a major theatre as well. Germany saw one of the earliest big moves. In 2011, a court in Düsseldorf granted Apple a surprise EU-wide injunction, temporarily banning the sale of Samsung's Galaxy Tab 10.1 tablet. For a moment, Samsung's iPad rival was off shelves across much of Europe. Samsung fought back, and higher courts later lifted some of these bans, but Apple had made its point. In France and Italy, Samsung tried a counter-offensive, seeking bans on Apple's iPhones for alleged wireless patent infringement. The legal ping-pong was dizzying. One week Apple would score an injunction in one country, the next week Samsung would get a win in another. Perhaps the most memorable chapter in Europe came from the United Kingdom. Tired of Apple's claims, Samsung took a bold step. It asked a UK court to order Apple to publicly acknowledge that Samsung did not copy the iPad, and the UK judge agreed. In a rather humbling turn, Apple was forced to post a notice on its website and in newspapers stating that Samsung's Galaxy tablets did not infringe Apple's designs. The UK judges even added a cheeky twist. In their ruling, they remarked that Samsung's tablets were not as cool as the iPad, implying consumers could tell them apart. It was an unusual way to say Samsung didn't copy. Essentially, Samsung couldn't have copied because their product isn't as stylish as Apple's. That one had to sting Apple a bit, even as it complied with the order. All these international cases highlighted how complex and fragmented patent law can be. A design element protected in the US might not be viewed the same way under European law. Some countries are more willing to issue product injunctions, others are reluctant. Apple and Samsung each accuse the other of forum shopping, looking for courts likely to favor them. It truly was legal warfare on a global scale, costing both companies huge sums in lawyer fees and resources. After a couple of years of this worldwide crossfire, fatigue set in. By mid-2014, Apple and Samsung decided to call a partial truce. They agreed to drop all patent lawsuits outside the US. The global battles had been raging for 3 years, spanning a dozen countries across Asia, Europe, and Australia. Now both sides essentially said, "Enough. Let's fight this out in one place, the US, and stop elsewhere." Neither side admitted defeat internationally. They simply realized the scorched earth tactics weren't worth it overseas. They did not strike any licensing deal, though. This was a ceasefire, not a peace treaty. By concentrating on the US, Apple and Samsung acknowledged that the biggest prizes and penalties lay in American courts, which had awarded the largest damages. And indeed, the US fight continued intensely. But stepping back from the global stage was significant. It marked the end of the broad smartphone patent wars that had entangled not just Apple and Samsung, but other players too. Google, HTC, Motorola, Microsoft. Many had their own patent spats during those years. Apple versus Samsung was just the most famous. The global settlement hinted that the industry was ready to move on, at least outside America's shores. An interesting footnote. While these two giants were busy suing each other, the smartphone market was exploding. From 2011 to 2013, Samsung surged to become the world's #1 smartphone maker, selling tens of millions of Galaxy devices. Apple continued its dominance of the high-end market, selling iPhones as fast as it could make them. In other words, neither company's business was exactly suffering from the legal war. Consumers were still buying phones in record numbers. Some banned models here and there had minimal effect on the overall market, which kept booming. It was as if the legal war was a high-stakes shadowboxing match running in parallel to the real market competition, where both companies continued to thrive. After the initial bombshell verdict in 2012, the Apple-Samsung saga entered a long, grinding aftermath of appeals and negotiations. Huge court victories make headlines, but in patent cases, they're often just the beginning. Samsung, reeling from the $1 billion verdict, immediately set to work chipping away at it. Their lawyers filed appeals, motions, and objections on everything from jury misconduct to the validity of Apple's patents. Thus began a war of attrition in the legal system that would drag on for years. One of Samsung's first moves was to challenge the jury's decision and the damages amount. And they succeeded, to a point. In 2013, Judge Lucy Koh found that the original jury had made some errors in calculating damages for certain Samsung products. She ordered a partial retrial on damages, which resulted in a reduction of the award. The $1.049 billion was later revised down to about $930 million, and then portions of it were further knocked out on appeal. By 2015, after various rulings, Samsung's owed damages stood around $548 million. In fact, Samsung eventually paid Apple roughly $548 million in late 2015 to comply with judgments up to that point, even as it kept fighting in higher courts. The once headline-grabbing billion-dollar verdict had effectively been cut nearly in half. But the squabbling wasn't over. A major twist came when the case reached the US Supreme Court, a rare destination for a tech patent fight. The issue at hand was design patents, those covering the look of a product. Apple's big win included about $400 million for Samsung's infringement of Apple's design patents, things like the iPhone's shape and icon grid. US law said a company infringing a design patent could owe all the profits from the product. Apple argued it deserved Samsung's full profit on those phones. Samsung cried foul. Should copying a part of a phone, like its front face or icons, mean handing over all the profit of the entire phone? That, Samsung argued, was overkill. In December 2016, the Supreme Court unanimously sided with Samsung on that principle. They didn't throw out Apple's win entirely, but they did overturn the way damages were calculated for design patent infringement. The court said that the article of manufacture infringed could be just a component, not necessarily the whole product. This meant the $400 million portion related to design patents had to be re-evaluated. It was a significant moment. It was the first time the Supreme Court had weighed in on design patents in over a century, and it was directly because of the Apple versus Samsung war. The case was sent back to lower courts to figure out a fair damages number under this new guidance. In a sense, Apple's emphatic victory on design patents had been tempered by the highest court in the land. By 2018, nearly 7 years after the fight began, both companies were clearly war-weary. There had been additional trials. For example, a second US trial in 2014 over newer Samsung devices, where Apple won about $119 million, a far cry from what it sought. There were endless appeals. One jury in 2018, on retrial, recalculated and came up with $539 million in total damages for Apple. Samsung was poised to appeal yet again. The legal costs had ballooned, possibly into the hundreds of millions. Observers joked that the real winners were the lawyers, who'd been in a perpetual billing bonanza. Indeed, by one account, Apple may have spent more on lawyers than it ultimately collected from Samsung. In May 2014, after Apple won the $119 million, The Guardian called it a Pyrrhic victory, noting Apple had sought over $2 billion and likely spent a fortune litigating for years. Finally, in June 2018, Apple and Samsung decided to settle their US disputes and bring the war to an end. In a brief statement to the court, the two companies said they'd reached an undisclosed agreement. The terms were confidential, but it effectively closed all remaining cases between them. After 7 years, the thermonuclear war was over. There was no dramatic public peace treaty, just a quiet legal filing, and the next day, business as usual. Both companies no doubt were relieved to put it behind them. So, what was the outcome of all this? Apple secured its point. It had some of its copying claims validated and got Samsung to pay a significant sum, over $500 million in the end. But Samsung, despite the hit, had grown immensely during those years. It became a dominant global player, and its Galaxy brand flourished. Importantly, Samsung's newer phones gradually moved away from the iPhone clone look. By the mid-2010s, Samsung was experimenting with curved screens, larger phablet sizes, styluses for its Note series, and distinctive design flair of its own. The smartphone landscape that emerged was one where Apple and Samsung became more differentiated in style. Perhaps the lawsuit nudged Samsung to innovate its design further to avoid future clashes. Or maybe technology just evolved that way regardless. There's also the question of precedent. Apple's aggressive use of design and software patents put the industry on notice. Other phone makers took heed not to make their products too iPhone-like in appearance. Some features that Apple patented, like the bounce-back animation, were changed or avoided by competitors to steer clear of trouble. In Android software, for example, that rubber band bounce effect was replaced with a simple glow at the edge, a subtle outcome of Apple's patent stance. You could say the war drew boundaries around certain aspects of phone design, a kind of do not trespass sign for future engineers. Ironically, even as Apple won battles, Android won the war in market share. During the 2010s, Android phones, led by Samsung, became the majority of smartphones in the world. Apple, for its part, secured its place as the most profitable phone maker, catering to the high end. The patent war didn't stop Android's rise, but it perhaps slowed down direct imitations of Apple's design. And it signaled that Apple was willing to use its enormous cash reserves as a weapon, a warning to any would-be copycats.